SJC-11090, Rivas versus Chelsea Housing Authority.
Let's proceed.
Thank you, Mr. Chief Justice, and may it please the Court. My name is Joshua Garrick. On behalf of the appellant Elizabeth Rivas, I'm joined by Stephen Callahan. The Chelsea Housing Authority has the affirmative obligation to provide housing to members of the indigent community. Consistent with this purpose, when there's a dispute, the Department of Housing and Community Development has created lengthy grievance procedures that must be followed and that carry the important goal of saving a tenancy and saving someone's housing when at all possible. In this case, Elizabeth Rivas' housing was terminated and was not saved because the Chelsea Housing Authority failed in at least 3 respects to comply with indispensable components of the grievance procedure. This includes failing to conduct a mandatory informal settlement conference, considering ex parte communications at the administrative hearing, and
which one?
At the grievance panel hearing.
No, at the board.
The Board of Commissioners hearing. So there was 2 hearings. The grievance panel decision, we submit there was no problems with ex parte communication. But then, when the matter was reviewed by the Board of Commissioners, there were 2 instances of ex parte communications.
Ex parte communications in the sense of evidence, or simply. I mean, what were the nature, again, explain to me the nature of the ex parte communications that you say that were inappropriate for this board?
Well, certainly, first of all, we don't know exactly what was said because obviously we weren't in the room. But when we deposed both Carmen Torres and Michael McLaughlin and asked them about these ex parte communications, what we found was that there were 2 ex parte communications that took place. The first was when Carmen Torres admitted that she presented her entire case to the Board of Commissioners after Elizabeth Rivas and her attorney had left the room.
She actually submitted the paper, the documents, right?
Oh, Carmen Torres. Yes. Well, no, the record doesn't actually say that. When she was asked what she said she would have presented her case as she had done at the hearing before. So again, we don't know exactly whether it was her just submitting documents, whether it was her saying, just reiterating what was said at the previous hearing. But we do know that the entire case that would have been presented at the second hearing, at the first hearing, was also given at the second hearing. The second ex parte communication, which was improper, was when Michael McLaughlin, the former executive director, admitted that he was asked questions about the MRVP program by one of the members of the board.
Well, why is that improper? He's the executive director. They can ask questions of the executive director. That doesn't have to be part of an adjudicatory proceeding. He's essentially the advisor to the board.
Yes, but the statute, Chapter 30A, Section 10, specifically states that if the board members take judicial notice of some aspect of the program, then the grievant is required to be put on notice of the type of communication that was provided, and given the opportunity to respond. And this is important because the crux of the issue before the Board of Commissioners was what does this ambiguous program requirement mean? How long can a guest stay on the premises? And when the executive director says to one of the entire board, who may or may not be familiar with the specific program requirements, that the law says 14 days, and that's not true because it's not articulated in the regulation that there's a 14-day limit, and Ms. Rivas or her attorney isn't present in the room to say, no, that's not accurate, then there's no question that Ms. Rivas wasn't given a fair shake, and it's no surprise that her benefits were terminated.
Do we know why they were not in the room?
No, we don't.
So we don't know whether they just walked out or whether they were told you must leave.
Well, respectfully, Justice Gantz, I don't think that that's necessarily a logical inference of what happened here. Ms. Rivas at the time was represented by counsel. Counsel presented her argument, presented his arguments on behalf of Ms. Rivas, and then at some point was dismissed from the room. And the record does say, if you look at the deposition transcript when we deposed Michael McLaughlin, he was asked if he had given if the Housing Authority had given testimony after the hearing had concluded, and his answer was yes.
Was this subject to the open meeting law?
I believe it was. And
Did they vote to go into executive session?
that was not clear from the record either.
All right, if they did vote to go into executive session, is there a requirement that whatever occurred in executive session be reduced to writing?
My understanding of the open meeting laws is if it was, in fact, an executive session, that Ms. Rivas would still be entitled to be present at the hearing.
The subject of the hearing?
subject,
Correct.
But is there a requirement of written minutes for an executive session?
Yeah, Justice Spina, that I don't know. I'm not an expert, but I do believe that even if it was an executive session and these types of ex parte communications were given at that hearing, I think that under 30A, that Ms. Rivas still would have been entitled to notice of whatever ex parte communications were given, so that she would then be given an opportunity to respond.
With respect to the 30A issue, the amicus brief argues 30A doesn't apply. This is a local housing authority. It's 249.4. What's the basis for saying 30A is applicable here?
Well, so and there's a couple things, and it's kind of a complicated question because first of all, this court has never definitively stated that 30A or the certiorari review is the applicable standard. And at all aspects, we pled both in our complaint, and during the entire proceeding before the Housing Authority, before the Superior Court, and before the Appeals Court, the Housing Authority acted as if it was acting under 30A, and the decisions were all given in furtherance of 30A. The fact of the matter is it doesn't matter because
I'm not saying it does. I just seemed sort of this.
Why doesn't it matter?
Well, it doesn't matter because the avenues of judicial review are essentially the same. You have identical standards of review depending on what the issues are.
Well, if 249, I mean, really is arbitrary and capricious, right?
Well, it goes beyond that. You can also review errors of law. You can also review factual issues under the substantial evidence.
If the underlying proceeding is basically an adjudicatory proceeding, you review it as though it were an adjudicatory.
Correct, and I think that that's embodied in the Superior Court's standing order, which governs the procedure in the Superior Court as being the same for certiorari or 30A. The fact of the matter is, the only difference here is that one is statutory and one is an equitable remedy, and I think it's important to note that under the statutory provisions of 30A, there are due process requirements such as the right to cross-examine. In this instance here, where Michael McLaughlin had given guidance to the Board of Commissioners under 30A, there's a statute that provides that the grievant be given the opportunity to know what those comments were and rebut.
Let's assume for a moment this was a board. It wears a couple of hats here. It's not only the management board, but it's now serving in another capacity, which is an appellate review board. Here's the evidence, takes a break, speaks to in-house legal counsel about issues in the case. I take it that would be appropriate. That doesn't have to be part of the proceeding, or does it?
Well, I don't think that speaking with legal counsel is necessarily a part of a grievance procedure. I think here
maybe they have some questions of their counsel they want to speak to.
So if they do, what's the harm in involving Elizabeth Rivas in that process? I mean, the whole point here is we need transparency. We need to know what are the reasons why Elizabeth Rivas's housing benefits are being terminated.
And this was not made clear?
It was not made clear what the communications were.
But it was made clear why she was being terminated.
Well, we know the reasons why they sought her termination, but we still don't know what exactly the Housing Authority believes she did wrong. They said that she didn't report a change in household, but we don't know what the standard of the term household is, and we don't know.
What's that got to do with whether they sought advice from their either executive director or legal counsel in connection with making a decision? That got to do with whether the decision was sufficiently articulated?
Well, I don't think that asking legal counsel for an opinion would necessarily carry any weight here.
Well,
because
these boards generally, they don't operate simply on their own. They'll have someone in authority in the agency give them advice. I mean, I don't see what's wrong with that from an administrative law point of view.
To me, if you're asking general counsel to make an opinion on whether or not someone's housing benefits should be terminated.
Not someone's housing benefits, but what is the status of the law on this particular issue? I mean, I don't understand why that has to be.
McLaughlin's not a lawyer, is he?
I don't know that. I think he's a former legislator, if I recall. Okay. But I don't think that the housing authority. First of all, the housing authority has absolutely no authority whatsoever to interpret a ambiguous regulation. And first of all, you're going to realize that you're dealing with a regulation that was promulgated by the department.
So the board had no authority to interpret this regulation. So how do we resolve that?
That's a matter for the courts. And that's what we did on appeals. We sought the court's intervention to ask, tell us what this regulation means, because here you have a tenant who, in good faith, did what she thought was required under the statute. She told her mother she could only live with her for certain periods of the time, and at the end of the day, the housing authority, on its own, decided, you know what, that's not good enough. We're going to do what we want to do. And in your hypothetical, Justice Cordy, they could have gone to council and said, hey, she was there 14 days, and the housing authority council could have said, okay, you're right. But that's not what the law is. That's not what the regulation is.
But you're telling me Chelsea Housing Authority had no authority to even decide what the law was. So how does this play out?
Well, the way it plays out is if there is first of all, the law should be clear. The law should be clear what is prescribed and what isn't prescribed.
And the housing authority can't give it a first crack?
Absolutely not.
They can't interpret it or offer some interpretation of a regulation that they have to apply?
Well, they can make a finding. That doesn't necessarily mean that the finding is correct.
Well, I understand that it may not be correct, and we may be the final arbiter of what it means, but they can't attempt to interpret the regulation, apply the regulation to the facts of a case?
And here's why they don't have a first attempt. Because this is a regulation that was promulgated by the Department of Housing and Community Development, not the Housing Authority. And so and if you look at the cases dealing with interpretations of administrative regulations, it's clear that this falls exclusively with the province of the courts. And at times they may give discretion to the housing or to an agency, but those are in limited circumstances where the enabling legislation says that they can do that. It says that they've helped draft the regulation.
So are they supposed to decide a case in a vacuum?
No, isn't your point really? Aren't you really saying that their view of what the regulation means isn't entitled to deference? They didn't draft it, et cetera, et cetera. But as the adjudicator here, they have to apply it to the facts that are before them. You can disagree whether they did it correctly or incorrectly, and you don't have to give deference to how they interpret the regulation, but they have to apply it, don't they?
You're right, that they would be given the deference in applying the facts of this to the case here. The problem is, if you look at the decision, we don't know what facts they found. So we're no closer to there were conflicting affidavits. There was ample evidence on both sides, and we never know what exactly the housing authority found.
Well, that really goes to the question of whether or not the written decision was adequate for review on appeal.
Yes.
Not whether the housing authority had the authority to interpret and apply the regulation.
But it's one more in a series of procedures that the housing authority just blatantly disregarded. And it goes back to the informal settlement conference that should have been conducted at the beginning of the grievance with the goal of saving the tenancy before it ever got to the grievance procedure. And here, where the informal settlement conference was not conducted, she wasn't even told that she was entitled to one. She was prejudiced from the start. Well,
here she's received this notice. She gets a lawyer. There's a hearing set up fairly promptly. The lawyer doesn't say, well, have you had your informal conference yet?
So the facts are a little bit backwards. Yes, she did eventually retain an attorney, but if you look
that happened pretty quickly because she received the notice in sort of mid-July and the hearing was in early or mid-August.
When she received the notice, and the notice is at A120 in the record. I'm sorry, A121. It says that the first step is the grievance hearing. At A120. Elizabeth Rivas responds in her own writing, in her own words, unrepresented by counsel, I wish to file a grievance consistent with that letter. She's unrepresented at the time. She doesn't know that she has the right to an informal settlement conference. And I think it's important to understand here that you're dealing with a population of people
but she now has a lawyer, a lawyer who understands housing law. That's what this lawyer does. The lawyer doesn't say to the grievance panel, We haven't had an informal settlement conference. It's required, so we need to do that first.
Well, now we're shifting the burden from the housing authority, who's mandated by regulation to notify the tenant of the hearing and then conduct one. I mean, the language is clear.
All right, so I guess my question goes to the prejudice here. What's the prejudicial part of here, and prejudice and waiver?
Sure. Well, so first of all, I'm not entirely sure we do have to show prejudice, but we can, because here you have a indispensable component of the grievance process that is a process that is included in many of the different housing programs, where it's an informal setting, it's less intimidating. You can discuss circumstances that are lesser harsh than termination.
Would she have I mean, I've looked at the transcript, and she certainly put all this information in front of the grievance panel. It wasn't that she didn't have an opportunity to explain the circumstances. She did. But
it's unclear whether or not the grievance panel has the authority to look and say, oh, you know what, there may have been excess subsidy paid, you owe us $2,600. The statute says that they can order whatever relief is necessary, but I don't think that they would be within their discretion, because you have a member of the public at large, you have another housing tenant, and I don't believe it's within their discretion to compromise. The whole point of the informal settlement conference here is to save the tenancy and to provide an informal.
But at least if there were an objection to the failure to do that, somebody could have taken corrective measures and said, okay, you're absolutely right. Let's go back to square one and give you the settlement hearing. If you don't object, then
and I think that goes
the issue's not preserved.
Well, I think that goes to this issue of waiver. Waiver can come in two forms. One, like you said, not preserving something on the record, but the other part where someone waives their rights to something requires an affirmative act on behalf of someone, knowing that that's what they're doing. And here,
not always is waiver by conduct. I'm not suggesting that her request for a grievance hearing was a waiver. Quite the contrary. She wasn't represented by counsel. She obviously hadn't been informed. But when she's represented by counsel, and now you go through 2 hearings and don't raise the issue, I mean, isn't that waiver by conduct?
Well, respectfully, I mean, the decisions, the procedures are meant to be informal, but they're not meant to be disregarded. And here, where you have a hearing that is required by regulation and by the grievance procedures, and the housing authority blatantly ignored its obligations to do so, we would be turning everything around by placing the burden on the indigent population to say, where's my hearing?
Now, this was raised in the Superior Court.
Correct.
And there was no claim, I take it, by the housing authority that you waived this issue in the administrative proceedings by not bringing it up at the time.
Right. I believe they pled in their answer that there was waiver, but they never affirmatively argued it. They never raised anything beyond that. So to answer your question, I believe that they waived their opportunity to contest the waiver.
But they won on other grounds.
Well, we don't know what they won on because the Superior Court judge just signed off and said, drawing reasonable inferences, as did the hearing officer, we're going to affirm the decision.
Okay.
Thank you, sir.
Thank you.
May it please the Court. Thomas Feeney appear on behalf of the Chelsea Housing Authority. Good morning, and thank you for this opportunity. If I may address what the Court has just been addressing with my brother counsel. The first thing I need to say is that, and understandable, he's counsel for a MRVP recipient. So he presents facts that were provided to the grievance panel that the grievance panel found were not facts. What we have here in background is somebody who defrauded the housing authority.
Well, that's your conclusion, but tell me, when does somebody who resides in a apartment become a member of the household?
Well, if they're living there for approximately 11 months out of a year, at that point, and if I may step back for a second.
Even if they're living there for only half of the time during those months?
even if they're living there for 6 months out of the year.
And what's the
Okay, but
regulation?
and where do we find that? Where does somebody who is a tenant who is receiving rental assistance and therefore is indigent, how are they supposed to know when a boyfriend, a mother, a relative has stayed long enough that their income is to be attributed to them? Where do they go?
Well, and you've done there are two analyses there. And let me just, and I'll answer that question in just a second, but you said when their income can be attributable to them. There was no question at the grievance panel hearing that there was information, substantial evidence submitted that not only was her mother, Mrs. Borges, living there, but she was also contributing to the household, notwithstanding whatever income she may receive on her own. She was paying the bills. And so that in and of itself would have warranted termination of the MRVP voucher. But to answer
and where is that? Where do I find that in the regulations, that if anybody contributes any amount of money to the household, they have become a member of the household?
No, there's two separate analysis.
But to show me in the regulations where somebody, or show me where in any application, show me where somebody can, who is a tenant, can read this and know where the line is.
On the MRVP voucher and the recertification, each time it asks them to certify what their income is.
Right. I understand that. But the question is, when does somebody else's income is to be attributable to them or to be added to the income of the household? That's the issue.
Well, and if I may address two different things and split that a little bit, because what you're talking about are two different things. One is when can that person's income be attributable to the household, and that's when they become a household member.
Right.
Then there's also whether or not they're a household member or not. If they have parents living in California and they contribute income or if they contribute funds to the running of the household, that income by regulation is attributable to the income of the household member.
And tell me the regulation where that's found. Where do I find that?
I don't have the regulation off the top of my head, Your Honor. I apologize.
Is it in the calculation of income?
It is. When they're asked to recertify, they're asked for, and there's not a dispute as to whether or not that would apply, which is what has bothered me during this litigation, is that.
So, and you're saying that, of course, we don't know whether or not. Do we know that that was the basis of the finding, that she was receiving income from the mother, and therefore, for that reason alone, she was viewed to, that income was now treated as the income of Ms. Rivas?
No, they found
Changes in family composition and in family's income. That's
right.
what.
And that change in income can happen in two different ways. One, presumptively, when the family composition changes, then that person's income automatically comes along. Or if the income changes, where you're getting, whether they're characterized as gifts, but if you're getting funds to help run the household. And in that case, they found both that Rivas had failed to report the change in household composition and change in income.
Now, does this happen fairly frequently, this sort of thing?
No.
Well,
Well, at least not in my experience with the.
So why didn't they have a settlement, an informal settlement conference?
Well, you also answered your own question, because typically this kind of litigation doesn't happen frequently, because that's exactly what they do. They really only prosecute I apologize. The reason why it doesn't go to court that often is because they do resolve these things informally. They do work out payment plans.
So why
But that didn't happen here.
That didn't happen here because there was, and it could have still happened even at the grievance panel. The regulations.
But isn't that your obligation to schedule that?
According to the HUD regulations, yes, Your Honor, it is. And that didn't happen in this case. But there is speculation, well, if that happened, we could have, if you read the we could have convinced that one person that this was all a mistake and that a payment plan for the $2,600 could have been entered into. But if I may recharacterize that, what was happening here, and happens quite often, is that it's a gamesmanship. It's, well, if I get caught, all I have to do is repay it. But if I don't get caught, that means I win.
But in this case, it's a peculiar game because the mother she had moved up from Virginia or someplace, and she doesn't have a place to stay. She applied for an apartment at the Chelsea Housing Authority, which normally, in her circumstances, I take it, would occur in a couple of months. And it took 13 months for that to get processed.
I would disagree with you, Your Honor.
Okay.
Because one, and once again, that's, I would say, a mischaracterization of the facts. They being Ms. Rivas, through counsel, kept saying that, well, no, she had applied way back when. It took 13 months. We don't think that that's credible.
You didn't accept her asset, right?
We have the application came very quickly. After she applied, she got it very quickly. What they're arguing is that, well, no, in fact, she had applied when she first moved up. But that's not what the facts and what the record shows. What the record shows is that she actually applied much later than that.
Could we just go back, and I know we've been making you skip around all of this,
Okay.
but to Justice Gantz's question, what are the regs, whether they're HUD regs or department, state regs, that say, that define when somebody becomes a member of the household in terms of how long they're staying there? And there's something about 14 days somewhere and something else that says 21 days in the course of I don't know. I'm looking for these regs.
And it is not clear, Your Honor.
Well,
I agree.
I only can find would I look in 760 Code Mass Regs?
That's one place to look, yes, Your Honor.
And would I look at Section 4903 eligibility for program?
Yes.
And then would I look at in the appendix, well, after the blue brief at Add 28, which says that requirements for continued participation right? Is that where I would look? 9
months. Well, there are a number of regulations.
But I don't actually find the specific you're talking about anywhere.
Because
they reference to the voucher, which doesn't also tell you. And
unfortunately, the MRVP voucher is separate from the Section 8 regulations. And that's why, circumstantially, you heard Ms. Rivas submit an affidavit. There's no accident that she says 2 weeks, because she's aware of the regulations for the Section 8 recipients and other housing recipients that says that if somebody's there for more than 2 weeks, then they're no longer a guest. And that's why we postulate that she submitted that affidavit that just coincidentally happened to cite that 2-week period.
Okay. Well,
So I'm so sorry. So what's wrong with falling within the limits of the guidelines? I mean, if the guidelines say you can stay no more than 15 days out of the year, what's wrong with somebody trying to comply with that and saying, I'll have the person stay 14 days?
Well, and that's fine, but that was 14, even accepting her affidavit, which they don't have to do, that's 14 days out of every month, not out of the year.
Okay, but you still haven't answered the question. Where is the line? Tell me where the line is where somebody who is staying in a rental unit has crossed the line. Where's the line?
In this case, the line is whether or not the household composition has changed, and you have a regulation that says that a person's primary residence is if that person is living there for 9 months or more.
And
where do you find that?
That is listed in my brief. Excuse me. I apologize. It's for the residency determinations.
Right. You're referring to 76503. The primary residence is defined as the principal home, domicile, occupied by all members of a household not less than 9 months of the year. That's the definition of primary residence.
Correct. And what happens is that is that even, and once again, I'm dealing with regulation that if we were talking about whether or not Ms. Burgos was there for 20 days versus 14 days, we'd be here under a different calculus. We're here with somebody who was living with her, and they found that who was living there for almost a year.
Okay, but are you saying that reg refers to principal home paren domicile? Are you saying that was her domicile? Is there a finding of domicile here?
In this case, the finding that Ms. Rivas had failed to report a change in household composition, her household composition had changed. So yes, that's exactly what they were saying. That you have somebody living with you. She is domiciled there. They didn't use the word domiciled.
They didn't, right.
No, but instead what they did, they put the burden on Rivas that you failed to report the change in household composition.
The question I have, I guess, is, somebody has a parent who was visiting periodically, maybe visiting to take care of a child 1 or 2 days, maybe a week or two. Where do they look to find out where it's too much? What are they supposed to do? How come? And this is not an unusual circumstance.
No, it's not. And if we had that circumstance before the court, I may be making a different argument. But in the circumstances, under the totality of these circumstances, what's before the court now, no reasonable fact finder could find but that, and I'm putting it in a different term, but there was substantial evidence before the agency for them to find that Rivas had failed to report the change in household composition.
But you're also saying there's no place where a tenant could look and see a clear-cut statement of how long is too long.
Not for the MRVP voucher program, that's correct.
Let me go back to a point you made earlier, though. I want to make sure I understood. I believe you said that you conceded it was your obligation to schedule the informal conference.
That's what the regulations appear to require.
And you did not do that.
And they did not do that.
And why doesn't that end it right there?
Because it's a mere technical violation of the regulations applicable to the housing authority. And when we're here in a courtroom on review of that, and this is where it's important whether or not Chapter 30A applies or 294.4 applies.
You say 30A applies, right?
And that's what we've been operating under. Although, in reading the cases that my brother Creighton had presented to the court, there are cases where it says that a housing authority is not an agency per se. It's a body politic and corporate, but given the powers, I would argue that 30A would apply. The housing authority has always run its hearings based on 30A, but what controls is that property interest. And so, inasmuch as she has a property interest in that voucher powers, then due process has to be used to deprive her of that interest. And that's where we would look, and that's where I'd like to make a point about the Board of Governors review. What Ms. Rivas was entitled to was one hearing that complied with due process. And she, without question, without dispute, was provided that.
Well, but the regs provided her with a settlement conference, and she was denied that.
Well, and that's where, upon review, is her burden to show prejudice and under 294, manifest injustice.
Well, isn't there a big difference between a conference whose purpose is settlement versus a grievance panel whose purpose is adjudication and who is comprised of 2 out of 3 people are not even members of the commission to be able to negotiate a resolution?
But they could. The grievance panel could, and have in the past, issued, and in this case, the grievance panel was presented with not only her violations, but also the fact that based on the income imputable, she would have owed $2,600 and change. The grievance panel, as a compromise, chose to not award the housing authority that $2,600. Instead, what they said that no, we're going to take away the MRVP voucher.
Has she left the housing authority?
Well, she never in the housing authority, but the MRV.
Has she left the MRV? She's left the MRVP.
That particular voucher no longer exists.
Okay.
And if I may explain, it may help a little bit, that there are two types of voucher in MRVP program. There's project-based vouchers and there's individual vouchers.
The project.
This was a project-based voucher, and the individual who, which is not in the record, unfortunately, the individual who owned that voucher has since turned it in, so it no longer exists. But
But the program still exists.
it does, but it's sort of frozen in time. They're not refunding it, and so, but they are passing on the individual vouchers to somebody else as they turn them over.
So
Although
is she still have any kind of a tenancy relationship with the housing authority?
she never had a tenancy relationship, she had only MRVP voucher relationship.
Do you have any relationship?
She does not.
Well, we're going to have to leave it there. Thank you.
Thank you, Lawrence.